Ready, start. However, it is argued before this court that the preparation of the preliminary examination result was in pursuance to the unamended rules as the interim relief was granted and all the candidates were permitted to continue. However, the cutoff was 113 marks, and it is an admitted position that both the petitioners have not achieved the target. The preliminary examination was only to consider the eligibility of the candidates, and if the candidates are eligible, they are to be called for appearing in the main examination in the ratio of 110. It is nowhere mentioned in the writ petition that how a candidate who cannot even touch the cut-off marks can be permitted to appear in the main examination, and how the result of the preliminary examination which was prepared by the examination cell is defective. It is only an apprehension of the petitioners that once the validity of the amended rules has been upheld by the division bench of this court as well as by the Honorable Supreme Court, then there will be a scrutiny of the candidates which will be done prior to preparation of the main results, and all those candidates who are not having the benchmark in terms of the amended rules, they will be thrown out of the final list. Therefore, there is every possibility that the petitioners may have chance now of achieving the benchmark, but the fact remains that the petitioners could not even attain the cut-off marks in the preliminary examination. The sorting of the candidates after the main examination is over will not create any possibility that the candidates who have not even attained the benchmark in the preliminary examination, their names can be considered in the preliminary examination list or in the main list. In absence of any explanation that could be given by the petitioners to the aforesaid, no benefit could be extended to them. Even otherwise, all the candidates were permitted to appear in the examination in terms of the interim order granted by the Honorable Supreme Court. But once the validity of the amended rules has been upheld by Honorable Supreme Court, no benefit can be extended to the petitioners. The admitted position being that cut-off marks in the eligibility examination could not be obtained by the petitioners, no relief can be extended to them. It can be seen that the contention raised by the respondents as regards a recomputation of cut-off marks was only on the basis of their apprehension. The High Court found that excluding ineligible candidates would not result in reducing the cut-off marks, and there was no likelihood of the respondents being considered for the final examination. The respondents could not furnish any explanation in that regard. Thus, the contention raised by the respondents based on a likelihood of reduction in the cut-off marks having been turned down, it was not open for the High Court in exercise of review jurisdiction to reconsider the very same contention and hold otherwise.